Royal Dutch Shell Plc is facing fresh legal challenges to its planned seismic survey of South Africa's eastern coastline, with local communities seeking to halt the program. On Thursday, South Africa's energy minister defended the oil major's plans for seismic oil exploration along a pristine coastal stretch, saying critics of the plan want to deprive Africa of energy resources. Environmentalists and others have protested against Shell's plans to start seismic blasting on the Wild Coast, which is home to some of the country's most undisturbed wildlife refuges and is also a major tourist draw. Critics say the blasting on the East Coast threatens marine wildlife such as dolphins, seals, penguins, and endangered humpback whales. The locals also fear that the seismic surveys conducted over 6,000 square kilometers will kill or scare away the fish they depend on for their livelihood. The case, filed last week, comes after a South African High Court dismissed a request for an interdict from a group including Greenpeace. The petition had sought to stop the plans on grounds including that it may cause irreparable harm to marine life and hurt the livelihoods of those who live off the sea. In a statement, Shell maintains that it takes the concerns of local communities into account and is adopting international standards to mitigate the environmental impact of its activities. In addition to the legal action, Shell has faced countrywide protest over its plans in South Africa and a call for a boycott of its gas stations. How much of a say should host communities have regarding their resources? What ethical business considerations does big business need to make in doing business? Today, we're looking at the case for doing ethical business practices. I'm Tolulope, Adeleru-Balogun. Welcome. This is Business Edge. Joining me now is Ricky Stone. He's an attorney at Cullinane and Associates in South Africa, representing those who are involved in this case. Ricky, thank you so much for joining us on Business Edge and welcome.
Thank you, Tole, and good morning to all your viewers in West Africa and all around Africa.
Thank you. So your law firm is basically representing the South African campaigners who are taking Shell to court over these plans for this seismic exploration and survey. So take us through a bit of what the challenges are. Why are they challenging Shell's plans for this oil exploration along the Wild Coast?
Okay, look, it's a fairly long story, which effectively started in 2013. So at the time in 2013, Impact Africa Oil, which is the 50% owner in the exploration right with Shell. Shell only recently came on board in this year, in August 2021, as the operator. So in 2013, they undertook an environmental management program, which was compiled as being a requirement to apply for an exploration right, which obviously then entitles you to various rights, including the right to undertake seismic surveying. So at that time in 2013, I was representing various clients, 77 interested and affected parties. We submitted extensive comments on the environmental management plan, and I suppose reasonably thought that was the end of it. We never heard back that any exploration right was ever granted. And then in the first week of November 2021, the notice of commencement for the seismic surveys was put out in the local press and sent to various interested and affected parties. So it came as quite a surprise to many, including myself as the attorney being involved since 2013, and the litigation then flowed from that.
So if I'm getting you right, it seems to be there was either a skipping of some of the processes or not keeping to the laid down processes, because as you said, there had been some kind of formal complaints regarding the environmental reports, and now jumping to November or December, hearing that they're going ahead with the seismic. What should have happened in the meantime that did not happen?
Well, okay, look, firstly, in 2014, all the interested and affected parties should have been notified by government that the exploration right had actually been granted. There then were various other requirements to be notified along the years. So, for example, an exploration right is only valid for a period of 2 years. You need to apply for a renewal. And So it's in its second renewal at the moment, which then entailed the submission of what's called an environmental compliance audit, which was undertaken in 2020. So there was certain notices in respect of that process. However, many of the receivers of that didn't receive it, sent as a mass email. Certain of the addresses were no longer in existence. And then, of course, in South Africa, we've got a well-established principle of consultation and public participation, where notice itself is only one aspect. So it's not a formalistic approach. It's actually, you need to directly engage with communities and parties that are concerned. So that's where we find ourselves now.
Okay, so now just days after the appeal was filed, a South African High Court found that your clients, applicants, have failed to prove there was a reasonable apprehension of irreparable harm without an interdict against Shell's plan, and actually found in favor of the oil firm because of the financial cost of a delay. So in terms of the legal aspect, the legal challenging of the plans, is this the end of the road? What's next?
No, look, it's certainly not the end of the road. I like to say it's the end of the beginning, and it's a far longer road ahead. So we've consulted with our clients that participated in that first interdict and are giving them advice now on their prospects of success on taking that judgment on appeal. There's a second interdict which has been set down in the same court, Grahamstown Makanda High Court, which has been brought by Sustaining the Wild Coast nonprofit company, and then various communities and small-scale subsistence fishers along the Wild Coast. So there is a second interdict that has been set down, and that will be heard next week, Friday. Look, in respect of our approach, we had sought undertakings from Shell that they would at least agree or give an undertaking that they wouldn't do the survey, particularly during the month of December. Their own environmental management program makes it quite clear that December is not an appropriate time to do it, particularly because of the migration of certain of the whales, such as the southern right whale and the humpback whale. That undertaking wasn't granted. We also sought intervention from various ministries, so the Minister of Mineral Resources and Energy, to suspend the operation of the right and the survey itself pending an investigation. So because there was government didn't issue the notices that we asked them to do, it was a matter of working over a weekend to get papers into court on a Monday and to have the matter argued on the 1st of December, which was the day that the seismic surveys were due to commence. And we were, of course, looking at the vessel on marine traffic, and we could see that it was moving at some speed to get into the survey zone. So our approach then to the interdict was, in effect, to ask for a very short interdict of 7 days or 10 days, which would then have given each of the parties, us and Shell and their attorneys, the opportunity to supplement our papers and to introduce further expert evidence in respect of the irreparable harms.
Okay, so part of your argument is that Shell's exploration amounted to an unjust administrative action because it was approved using an outdated approval process that has since been replaced by stronger environmental protections. Now, these are things that are meant to sort of happen from the government level. Government is meant to set the regulations and set the standards for how companies that might be involved in environmental activities are to behave. So when we look at what your case is, unjust environmental administrative action, also saying that it's an outdated approval process, take us through what that is, particularly for your clients.
Yeah, so look, there's various layers. The unjust administrative action is founded upon rights which South Africans have to just administrative action. So by virtue of being a citizen in a transparent and democratic society, you have the right, a constitutionally enshrined right, which is then codified through further legislation to just administrative action. So, and the judge in our interdict hearing, although he dismissed it, he did find that we have very good grounds and prospects of success in actually challenging the particularly the second renewal of the exploration right. So those judicial review proceedings would be something that we will look at instituting fairly soon. Then in respect of environmental aspects, South Africa have very comprehensive environmental protection laws under the National Environmental Management Act and various other pieces of legislation which flow from it, such as the Biodiversity Act and the Integrated Coastal Management Act. And these are all pieces of legislation which the decision maker, in this case, the Minister or the Director General duly delegated of the Department of Mineral Resources and Energy, they are bound to take those environmental protection laws into account when making their decisions. And it's quite clear, based on their own papers, that none of those pieces of legislation were taken into account. So on the one hand, it offends the principles of just administrative law. And then on the other hand, it offends the environmental protection legislation. So effectively, we went with both of those arguments, and that prima facie, on the face of it, the survey, which is currently in progress, is unlawful because a proper interpretation of the law dictates that Shell were required to undertake a full environmental impact assessment and apply for an environmental authorization. So that never took place.
All right, so Ricky, hold on. When we come back, I want us to look at what the court also said in terms of the financial cost of delaying this project and look at whether a compromise can be reached. And there was also a similar case somewhere in South Africa where the judge ruled that communities should give consent. How is that possibly playing out in this case? So we're looking at a case happening in South Africa right now where a community and, of course, local environmental activists are saying no to seismic survey that could affect local marine life. Do stay with us. And still with me is Ricky Stone for Cullinane and Associates in South Africa. His law firm is representing environmental campaigners against an exploration project off the country's wild coast. Now, many of South Africa's mineral resources are found on communally owned land and subject to customary law. And as such, the discourse on land in South Africa can be characterized by tension between communities who hold informal land rights, the state, which is empowered to award mining rights, and those who seek to exploit the land and its mineral resources for financial gain. A 2019 judgment required that Minerals and Petroleum Resources Development Act and the Interim Protection of Informal Land Rights Act be read together to ensure that prior to awarding a right to mine, the Minister of Minerals and Energy gets the full and informed consent from the community involved, as opposed to mere consultation, as is required by the Minerals Act. So, Ricky, let me bring you back in here. Looking at those acts, and as you said, that South Africa has quite a history of consultation and public participation in these issues. That particular case and the judgment from 2019, it has no bearing in this situation. Is this not a situation where Shell would have needed to consult with local communities?
Yes, look, I mean, I think the distinction in that case was that it was mining on land. And of course, well, at least in the eyes of a decision maker, there's a distinction between mining on land and mining in the oceans. But importantly, when it comes to the oceans, we've got and I briefly mentioned it, the Integrated Coastal Management Act. And in terms of that act, the coastal waters of South Africa, so our entire exclusive economic zone, is public coastal property. So that is for the benefit of every single South African citizen. And the state are indeed only the custodians or the trustees. They hold the coastal waters in trust for the benefit of all South Africans. So there was absolutely a requirement to obtain at least the informed consent of those communities. And I mean, just looking at what you're playing in the background there, those are specific communities from the Amadiba area in Tolulope. They have endured a 20-year battle against mining of sand dunes on their own land. It has divided that community. There have been assassinations as a result, but the resistance remains strong. And I think that the message is quite clear from the people that they understand the land, their connection to the land, and particularly their spiritual and ancestral connection to the ocean. And no matter the cost, they will use the courts of law to protect and enforce their rights.
So in talking about them protecting and enforcing their rights, it does get into a business conversation. This is a company that wants to do business in South Africa, that will pay taxes, that will possibly, of course, explore this oil and exploit it and add revenue and even bring employment. Now, in dismissing the case, the judge also noted that the financial costs of the delay to the projects were of concern. When you hear things like that, a judgment that's looking into the financial delays, when you think about the people who will be affected and the livelihoods, is there a compromise to be found? Is there a way for a company such as Shell to do business ethically that takes into consideration the hundreds of years of history that local communities have on their land, but also looks as to how the state as an entirety can also benefit from its natural resources?
Yes, look, I think it's a very nuanced and complex consideration. Look, if we look at the Wild Coast specifically, within that region, there are 4 marine protected areas. There's certain fishes that breed that are only endemic to South Africa, but they particularly breed within those marine protected areas. So the intrinsic value of the real diversity and biodiversity in those coastal waters is indeed something that needs to be taken into consideration. As to the potential, I suppose, for what exploration for oil and gas could add into our energy stream, look, I think that again is a very complex type of balancing act. The transition to just renewable energy and alternative energy streams is not something that will happen overnight. But I think when we look at particularly the history of Shell and the people of West Africa, indeed the Ogani themselves, will still bear very very deep wounds as to the consequences of these type of corporations in their pursuit of profit and the very real damage it can have, not only to the environment, but indeed to the communities and society as a whole.
So where is government? We've heard from the energy minister who has defended Shell's activities, the planned seismic survey that the company is about to take off. Do we have a date as to when they will start the seismic activity now?
Well, Shell's attorneys have confirmed that the seismic survey has commenced, and data from marine traffic itself shows that they have certainly commenced it, just judging by the formations and patterns that the vessels have been traveling in for the last week. So they certainly have commenced the survey. And I guess that's why there's a lot of importance on the second case. But yes, government's position in respect of minerals, I think, is well known. It's unfortunate. South Africa has a very long history of resistance against mining. And it's quite clear that now these cases are really bringing a lot of the past to the surface, and it's causing a lot of people pain.
Yes. And finally, let me ask, this is a conversation that spans across the continent: mineral resources, mining rights, the exploitation of Africa's natural resources. And of course, many governments will want to take advantage of the money and the revenue that these resources bring. But from basically Central Africa to Western Africa to the southern part of the continent and the east, as you said, we can see some of the damage. We can see the scars that are left in the wake of this. Is there a way to encourage citizens to demand that these companies that are coming in to do business in an ethical way, that they can make profits, but continue to be ethical businesses that respect the land, respect the history many of our communities have with the land, but also do what they need to do and make money?
Yeah, Tuli. Look, I think that's a very, very important point that you raised there. I mean, that you would expect that in this modern day and age that all businesses are ethical, but it's clearly not the case. As to the potential to the economy and the gross domestic product which could be raised from these type of projects, I think very often the the projections are very skewed. Mozambique and what was proposed there in respect to the oil and gas industries and the LNG industry is a clear case, you know. So I think it also really comes down centrally to the fact that as humanity, at least in the last 100 years, we've become an extractive nation, extractive people, you know. We treat the earth and the oceans as an object, as something that just is an infinite resource that can be extracted. And I guess that's why we are faced with the environmental crisis. So it's to me, in my mind, we're at a tipping point, and it's up to government and particularly big business to now change the narrative, to look at doing business in a more ethical manner, to look at fast tracking alternative and renewable energy sources. And of course, it's not something that happens overnight, but those are conversations that need to take place.
All right, Ricky, we'll leave it there for now. As you said, there is another, a second interdict that is ongoing, and we're going to see and follow up with you as to how that plays out. But thank you so much for joining us today.
It's only a pleasure, and enjoy the rest of your day. We'll speak soon.
All right, and it is an ongoing case, but also one that many will be watching as the world tries to move away from the natural resources in the ground. There is the conversation around how Africa can continue to take advantage of those natural resources, but taking advantage of those resources does come with risk, as many are pointing out, off the wild coast of South Africa. As the case continues to develop, we will bring you updates. What we are updating you on now are the stories we're keeping our eyes on. NC4 to watch is up next. And these stories have our attention, and they've made it to the list of stories you need to watch out for. Now, there seems to be a bidding war around Royal Bafokeng, or RP Plat. Now, the company announced that Northam Platinum Holdings made an unsolicited approach to buy some or all of its shares. Later, Northam said that the stake it had built in the company so far wouldn't trigger a mandatory offer to all shareholders. Soon after that, rival Impala Platinum Holdings said it now held 35.31% of RB Plat as it sought control of a miner that's key to prolonging the life of its own deep-level operations. The Africa Continental-wide Free Trade Pact could help boost economic growth and reduce inequality in Africa as the COVID-19 Omicron variant threatens to weigh on output. A United Nations report explains that commerce under the African Continental Free Trade Area that started January the 1st could reduce coronavirus-induced economic contractions and spur sustainable and inclusive growth on the continent if stronger support measures targeting women, young traders, and small businesses are implemented. China's top leaders are set to convene to decide the economic agenda for 2022, and analysts are expecting the focus to shift to supporting growth from deleveraging and regulatory crackdowns. The annual Central Economic Work Conference, attended by members of the Politburo Standing Committee, including President Xi Jinping, will be keenly watched for signs that reinforce the move to looser economic policy, signaled by a meeting last week. And finally, Nigeria's Debt Management Office, on behalf of the federal government of Nigeria, offered up 100 billion naira's worth of FGN bonds in December of this year. The bonds were listed in 2 tranches, each worth 50 billion naira. And that's this edition of Business Edge. If you've missed the conversations we've had this week on African business, the economy, and finance, you can head to our YouTube channel or also download our mobile app, and all of those episodes will be there live. Don't forget to follow us on social media. We are at News Central TV. I'll see you bright and early, 11 a.m. West African time on Monday, as we continue putting African business, the economy, and finance front and center right here on Business Edge. I'm Tolulope. Adeleru-Balogun. Have a pleasant weekend.